I may say so in a lighter vein. Seeing the direction of the wind, I'll be very brief. Lest I keep talking to myself.
But direction of the wind can change also.
That's what I'm saying. Lest I change the direction of the wind. If your Lordship is pleased to turn to volume 2, P7. I have one of the very short points to you.
Volume 2?
CP, volume 2, page 329. I am only going to assist your Lordship on 2 points which I need to assist. Was there a settlement? Yes. Suggestion is that this was something more than a settlement or less than an adjudication. And if so, on what basis is the settlement being challenged?
Salvi, it was a settlement. I don't think any of us doubt it was a settlement. Yes, court prods.
2 minutes.
At times, court prods, there's no doubt about it. Day in, day out in trying to arrive at settlements. We may have played the local scenario, the court may have played a little more active role in trying to do so. In family matters, every day we do it. Sometimes the bench comes, they say, leave it to this. Okay, we say X amount is a settlement.
There was a
You want
reason
to
why
agree to it, you don't want to agree to it. And then they say, okay, we leave it to the court too.
There was a reason why your Lordships did that, because the district judge had passed a judicial order asking the parties to settle or explore a settlement. So the process had been started by a judicial order. And that carried its, there were 2 parallel themes which were running. While the settlement was going on, the district judge said, I can't wait and see people queue up like this. Something needs to be done. So he passed an interim saying peso, which both sides challenged in the High Court. High Court upheld the principle but scaled it.
Scaled it down, and then that came up to
that came up in appeal. So there were 2 parallel tracks running. Try and settle, and in the meanwhile pay. Those 2 were sort of coalesced here, where your Lordship said settle, if you can. The appeal was argued for weeks and weeks in Court 1 before Justice Pathak, while there were also conversations happening about whether this can be settled, because this had to be not settled obviously at very high levels, at the top of the management of the private company and at the top of the government. It had very far-reaching implications. And that is what was done. So there was a settlement. Now, what has happened pursuant to that settlement? Your Lordship sees this one document so that the nature of the curative becomes clear. Page 329, P7. In the course of submission, various questions came up. Actually, what exactly was paid? Are there any claims outstanding? A lot of these matters are answered.
yes.
The death figures are 5295. These are paid. Death transferred to injury 10,000, permanent disability 3,000, temporary disability 33,000, injury of severity 40,000, minor injuries 521, loss of livestock 233, loss of property 547, PSU 8, total number of cases 5,74,000, compensation paid 154,856.
These are the figures given in the review application.
Curative application.
Curative. So this is how Malak they paid 1548. Came back to your Lordships saying we still have 1,500 lying in the kitty. So pro rata compensation given. Now, what the curative petition tells your Lordship is page 150 of volume 1, if the Lordship sees it side by side. CP1, CP volume 1. The Lordship keeps this page open and compares the figures.
What page are you referring to?
150.
150.
And if your lordship looks at D, column D, and compares it to the number of cases column at page 329, death 5295, permanent disability is actually 4902 as against 10,040. Sorry, permanent disability is 4902 as against 3199. Temporary disability is 35 as against 33. Utmost severity is the same, 42. Minor injuries, 521 to 527. It's not much of an increase. Loss of property, loss of livestock. It's not that what has been paid and what are the actual number of cases in the curative are dramatically different. What then are they claiming? They are saying compare the figures in D to the assumptions of 4th May 89. What we have assumed and what have actually transpired are different. Now, what had they assumed? They had assumed 3,000 deaths. It turned out to be 5295. They had assumed 30,000 permanent disability. It actually turned out to be 4,900. They had assumed 20,000 disability temporary. It turned out to be 35. Utmost severity was 2,000. It actually turned out to be 42. It's this 50,000 assumed. It became 5,27,000. Loss of property 50,000 turned out to be 555. Loss of livestock 50,000 assumed to be 230.
That even from the chart the attorney had given to us, where the figures were given, we had put to him the real issue is of the solace amount paid to the persons with minor injuries.
Not even that. That also has been paid.
No, paid it has, but this is where the figures rose.
The figures rose from what was assumed in 1989.
Yeah.
Now, the question of law, which your lordship have to consider in a curative, is if the Union of India, which was perfectly aware of the uncertainties of the situation, thought that that public interest would benefit by a quietus of signing the settlement at 470 billion in a full and final settlement, can come back and say, if you knew that the permanent disabilities would be 500,000 instead of 50,000, you would never have signed this settlement. And assuming that is so, does that become a ground to set aside a settlement? Point number one. Point number two, can you add top up? Because Union are not saying set aside settlement. They did. At one time they did. Today they are not saying set aside. And this is the fundamental difference between the review and the curative. Let me not put to one side the question about the procedure which your lordships have put, and the attorney has answered. There's nothing I can usefully add on whether, without filing a review, a curative can be filed. It is not merely a matter of procedure. There was something more troublesome there. If the union had to file a review, it would have had to elect on whether it wants to continue with the settlement or whether it wants to discontinue the settlement, scrap the settlement, and say, we don't care about the settlement. Start the suit.
So why would in a review they be required to say so?
It's binary. Either you stay with the settlement.
No, that's the same thing today.
No, exactly. So they don't file a review.
Even in a review, they would have said, look, we don't want to disturb the settlement, top it up, as they're saying in the curative.
They didn't.
They did. As a fact, they did.
No, what happened is something very interesting. Because your lordship will know the background. The review petitions. I'm not saying it may be that it's a technicality that the union representing the review petitioners did not itself file a review, but it came and supported a review, etc. So you may say, in that sense, broadly, the Hura test is satisfied. I'm going on that basis. Taking up time on it. But then that creates.
Having heard the attorney for such a long period of time, we are not going to shut him out because the curative has not been
Exactly.
taken. So
I am not wanting to point out something else. Your lordship tells.
Mr. Salve, one more thing, please. This was a settlement in this court. Now review is filed. Review is granted. Now, under Order 43, the grant of review is appealable, specifically as an order of court. Now, if you're going to shut him out on curative aspect, then it will lead to a very.
I'm not saying that. I'm not saying that. That's why I said.
that's what
I'm not addressing a lot.
we already indicated. We have flagged that issue, but on that,
That's why I said
I
I don't even
not
want
like to shut out the.
I only said I'm not going there. What I want to show, my lord, is something.
To that extent, you are right.
What I do want to show, my lord, is what exactly happened. To inform the court. Please turn to volume 6, additional documents filed by us. This is the review petition prayers.
You mentioned the review petition prayers were to set aside the settlement.
Yes, I want to say.
But that's by the other people.
The union said we support the review.
But the union never argued that the settlement be set aside at any stage.
I remember right in the opening, a subject matter dear to my Lord Justice Karuna and my heart came up, tax law. Because one of the first questions which came up was, having appropriated the money under a settlement, can you challenge the settlement? Then Attorney General, my guru, Mr. Sorabji said, we have not appropriated the money. We produced a copy of the finance bill. So there was a question of taxability of the interest on the purpose. So a provision was introduced in the finance bill appropriating this money and saying it goes to the exchequer. So there'll be no interest. There'll be no tax on the interest. So we said this constitutes appropriation. So this issue was very much at large. And what the union asked for is not set out fortunately for us. As Justice Venkatachalaya said, because nobody was hurt, we didn't keep it in the traditional confines of a review. Like your lordships have heard this case much beyond the confines of a curative. Their lordships, in fact, said we will hear if the settlement has to be set aside. That is what was being heard. Because at page 1433, just to get the record straight. The lordship read that rather poignant comment by Justice Rangnath. It's very easy to say, go try the soup for those who have no stake. Those who know the realities of the uncertainty of litigation will never make that clear. Look at page 1433. Review the orders of settlement. Allow the appeal of the Union of India against the Madhya Pradesh High Court and confirm the order of the District Judge Bhopal. The lordships have been on this. Direct the disposal of 350 crores as the interim compensation to the victims. So, my lord, this would be on the basis that the judgment goes. So, we are back with the appeal. allow the appeal of the Union of India against Madhya Pradesh because the High Court had gone to appeal down the pro tem compensation
Yeah.
from 400 to 250 crores. So allow the appeal of the Union, confirm the order, direct 350 crores as interim compensation out of the sum deposited by UCC. Retain the balance of the amount paid by UCC in the court as security to satisfy the final decree in the suit.
What was the total amount paid in court at that time?
Well, this was the total amount paid under the settlement, i.e. the 400 odd million. 470 million.
Probably before the district court it was 270 and the high court it was 140, and when it has come to this court then it was 470.
Yes. So, Malad, that is how, and that money was paid pursuant to settlement. So the review petitioner
I
said,
was only saying what was the amount which is already in court, either in district or high court.
no,
or-
Five.
at the time this was filed,
Yeah.
the entire amount under the settlement had been paid.
So that was so you brought in more money under the settlement.
Yes, yes, yes.
So that's what I'm saying. I'm saying originally what was lying in the court was
5 million.
deposited.
I don't think, I mean, subject to
So
correction.
pursuant to the interim direction,
There was a direction to pay.
I'm saying pursuant to the direction of the district court and the high court, was any amount deposited?
No,
or not
because that was carried in appeal.
deposited? So it was not deposited.
No.
That's the fact I want.
And the appeal came here.
That's fine.
Post settlement, the entire amount was brought in. And there's a certification, it's all noted.
So it's 5 million paid pursuant to the US Justice Keenan's order. 5 million. That was the
That, yeah,
only advance amount paid.
Okay.
Rest was all paid later on.
very small amount.
That's para 2A.
There's a very interesting thing I discovered in this. Although people retire, even in the US, they have the right to call back judges. Judge Keenan kept hearing the Bhopal case in its repeated avatars. Even post-settlement, Malad, 3 trials ahead. They used to call him back. I think the last order he passed was at age 90 or something. An action, because they used to call him back to hear the Bhopal case.
So the lighter side, your suggestion is all reviews here should be dealt with in the same manner.
But we have to seriously consider, even in the English courts, retired judges are so many times called back by the commercial court, come for a few days, sit, decide individual cases. Page 1433, Malad.
Yeah.
If your lordship sees the operative prayers. So what they said is of the settlement money which is coming, 350 you distribute, which is as per the interim order. Retain the balance as security to satisfy the final decree. Please mark the words. In the suit against street pending in the district court of Bhopal, and direct the speedy and expeditious disposal of the suit against the UCC by the district court and pass the consequential orders. The union filed a counter affidavit, which is at volume 7, and that makes important read.
In my review underline, like in my volume and yes.
This is volume 7.
Hmm.
Sorry?
What do you want to show us from this
Yes.
volume, Mr. Salve?
Please turn to page 1594. In the middle of the paragraph,
Yes.
the victim groups submitted.
Yeah.
The victims group submitted certain material and studies to the government. Thereafter, the government took a fresh look at the matter, with particular reference to the long-term effects and potential hazards of the exposure of MIC and other toxic gas. And it was realized that an important element involved in the determination of liability and the assessment of compensation damages was overlooked, as stated here and after. While directing settlement, the court took into account the number of fatal cases at about 3,000 and the number of cases of grievous and serious personal injuries as verifiable from the records of the hospitals of cases treated at Bhopal was taken to be in the neighborhood of 30,000. Obviously, one of these figures didn't come from Union Carbide, they could only have come from the government. It is submitted for reasons stated that the figures are not accurate and do not furnish a sound basis for assessment of compensation damages to the people who have been exposed to MIC and toxic gases. It is further submitted that medical studies on the effect of MIC and toxic gases formed in the leakage have been conducted under the auspices of the ICMR, and further studies are being conducted, and a whole chart of other studies is made. Your Lordship turns to page 1596. The results already obtained clearly show evidence of psychiatric disorders such as anxiety, neurosis, and depression, pulmonary damage, visual disorders. With regard to pulmonary damage, etc., etc. Then, my lord, page 1597. My lord, some suggestion being made at that time cancer was not known, this was not known. 1597, fourth line. Besides, there is a likelihood of carcinogenic effects which may be manifested over the years. Research and investigation in this regard are continuing. In addition to the studies of long-range effects are in progress in order to evaluate genetic risk, organic brain damage, damage to the immune system. Follow-up studies are being conducted in children, etc., etc. Page 1598, para 8. It is also necessary to point out that while the court proceeded on the basis that the number of dead was 3,000, the total number has gone up to 3,677. The figure is based on records showing ex gratia payments to the next of kin. It is therefore submitted there is every possible of the number of dead increasing as the various results of the gas leak manifest themselves over a period of time. Then, my lord, the environment damage, etc., is all mentioned. And the operative, then, of course, they challenged successfully the quashing of the criminal case. And page 1608, para 23. The union says the settlement requires to be reviewed. It is with this backdrop, I just wanted to read a few paragraphs from the review document. Two or three things, Paul, I just wanted to clarify. Page 39, I'm sorry, page 601, printing. I'm reading slightly some other volume. page 600, 601. I believe it's page 39 of the paper book, security paper book, but my lord may have read it. The attorney read it from some other volume.
So we had.
No, it is right. 39 is the right.
We had
601.
kept the file, that file.
So which is the paragraph number?
Paragraph 5.
The United States Court.
Yes. Something with Justice was read from Chief Justice Mishra's judgment. I just wanted to correct-
Para 39.
Yes. Page 39, para 5. The United States Court of Appeal for the Second Circuit upheld the first condition in respect. So, in fact, the two conditions was Union Carbide shall consent to submit to the jurisdiction of the court and continue to waive defenses based on statute of limitations, and Union Carbide shall agree to satisfy any judgment rendered by against it in the Indian court, and if appealable, upheld by an appellate court in that country. Whether judgment and affirmance comport with minimum requirements of due process. Now that condition, my lord, was appealed, and that condition was set aside. The U.S. Court of Appeals for the Second Circuit, by its decision of 14th January, upheld the first condition, and for the second one stated, if your lordship sees in the middle, it says of that passage, quoted under the New York law, which governs actions brought in New York to enforce foreign judgments, foreign country judgment is final, conclusive, and enforceable. Where rendered must be recognized and will be enforced as conclusive to the extent it grants or denies recovery of a sum of money, except that it is not deemed to be conclusive if the judgment was rendered under a system which does not provide for impartial tribunal and procedure compatible or procedures compatible with the requirements of due process of law. And added, my lord, over the page, any denial by the Indian courts of due process can be raised by UCC as a defense to the plaintiff's later attempt to enforce a resulting judgment against UCC in this country. Now, this is what the court was faced with. The explanation given, page 42, para 10. One or two things, page 604 of the report. One or two things required to be explained. The attorney said he will show your lordship's jurisprudence that a settlement can be increased or enhanced. And he has filed 3 American cases. He didn't read them, so I'm not dealing beyond pointing out. This is brought against British companies. So I'll talk about that. They have an interesting procedure in mass tort. This is a procedure under their. What happens is, unlike our systems, where your statement of claim, or particular of claim, or as we call it, claim, must set out your material facts, your basis, your evidence, and your summary of evidence, and your reliefs, and your cause of action. In America, you only file a cause of action. So and so has committed fraud, cheating, deceit. I claim so much. That's all that you do. Then the discovery procedure starts. Then you ask for all the documents, and then you go on filing particulars of claim. So the mass tort lawyer, they have one at the bar, divided the plaintiff's bar and the defendant's bar. So the mass tort lawyers, it's always who comes first and files the first claim. Multiple mass tort claims come to be filed, and of those multiple claims, then it becomes a race as to who gets the lead of the case. Now, in that manner, they have a procedure of a global settlement. So if there are 100 suits, you have a global settlement. All the suits of the mass tort get settled. Now, in that global settlement, you have a right to challenge. So different people whose suits are perforce getting settled, they can come and say this settlement is wrong, or these figures are wrong, or that figure. That's one of the two, including the one US Supreme Court case, which was cited, where a global settlement was challenged. And what are the principles? Now, we can't import all of that because none of that is relevant for us. In those mass fraud settlements, sometimes you insert what are called reopener clauses. That if a set of circumstances come into being, it will be reopened. Today, we're not inviting our lordship to add a reopener clause to our settlement itself and setting aside the settlement. The settlement was challenged in the review on the ground that in mass fraud cases, you must always have a reopener clause. This settlement did not have a reopener clause, therefore it's bad. And that was rejected. Second line. The fact that the Union of India has taken over the right to sue on behalf of all the victims indicates that if there is a shortfall in the fund, perhaps it would be the liability of Union of India to meet the same. Some of the observations of the Vairis bench support this view. This is not the Charalal Sahu case. The genuine claimants thus have no legitimate grievance to make as long as the compensation statutorily quantified is available to them, because the source from which the compensation comes into the fund is not of significance, relevance to the claimant. Nothing has been shown to your lordship, Maharaj, in the parliamentary legislation to establish that this is such an egregious error of law that your lordship must revisit this. But Parliament made a law saying Union of India will consolidate and pursue the claims on behalf of all victims. It was for Parliament to say that of the money received, to the extent received will be paid, to the extent not received will be paid. The Union of India will make sure whatever is paid is recovered from Bhopal, etc., from UCCS. So there was nothing. And when the union argued, they said, we are taking full responsibility. Because what Mr. Garg's argument was, you have taken away my right to sue UCC by the Bhopal Act. Nobody else, I can't sue. You've taken away my right to sue UCC. Tomorrow, if I'm not happy with the judgment, what happens? And the answer was, the government of India is accountable to you. That's how the law was upheld. That's what Justice Mishra is referring to. The virus bench, the virus judgment, which upheld the Bhopal Act, was on this basis. If your lordship now might move to the to para 16, 3 lines of para 15 are very important. In fact, Bhagwati Chief Justice clearly indicates in the judgment that his view is a departure from the law applicable to Western countries. We are not concerned in the present case as to whether the ratio of MC beta should be applied to cases of the type referred to in India. We have to remain cognizant of the fact that the Indian assets of UCC through UCI are 100 crores. For any decree in excess of that amount, execution has to be taken in the US. And one has to remember the observation of the Court of Appeals that the defense of due process will be available to be raised. The decree to be obtained in the Bhopal suit would have to be a money decree. It would be subject to the law referred to in the judgment of the US Court of Appeals. If the compensation is determined on basis of strict liability, a foundation different from the accepted basis in the US, the decree would be open to attack and may not be executable. Nothing has been shown to your lordship that this is an egregious, made some horrible mistake in coming to this conclusion. Today, your lordship is told, please apply NCMAP. But the review bench heard that argument and said, no, sorry, we are not going to do this because we don't want to put in peril the ultimate recoverability. Then, my lord, please turn to Justice Venkataraya's judgment. It starts page 48, para 25. It begins here. And the point which the attorney made at page 50, para 30. the last line, in fact, are against his point in the curative. The hazards of exposure to this lethal poison are as yet an unknown quanta. So the court is perfectly aware that we don't know where this is going to end. It's not that now you realize that you don't know where this is going to end. You knew then that you don't know where this is going to end. Page 51, para 33, last four lines. One of the points urged is that the likely long-term effects of the exposure have not been taken into account in approving the settlement, and the only way the victims' interests could have been protected against future aggravation of their gas-related health hazards was by the incorporation of an appropriate reopening clause. So this was argued. I can understand, in my humble submission, I perfectly understand this argument if you are challenging me, saying, look, a settlement without a reopener clause should be set aside. Then, my lord, please turn to page 55. And, my lord, this should be the last word as far as this is concerned. Where at paragraph 45, your lordship say, on February 89, this court recorded an overall settlement of the claims in the suit for 470 million. I'm reading page 55, printed page 617. The first two lines of paragraph 45. So this one closes the debate. The old Alture principle must apply now. What is said in a judgment is the last one. If your lordship say this is the settlement, this is the settlement. Look at paragraph 46, first three lines. On 15th February, the terms of settlement signed by the Attorney General for the Union of India and the Council for UCC was filed and the whole memorandum was set up. Then came the consequential orders. Paragraph 48 at page 619. The first sentence is important. The settlement is the same in this review petition and writ petitions on various. So the settlement was squarely challenged. Page 621, paragraph 54. At the outset, it requires to be noticed that the Union of India, which is the party to the settlement, has not bestirred itself to assail the settlement or any motion of its own. However, the Union of India, while not assailing the factum of the settlement, has sought to support the petitioner's challenge, please mark the word if you don't mind, to the validity of the settlement. So the Union squarely challenged the settlement. Learned Attorney General submitted that the factor of a compromise or settlement recorded is not disputed by the Union of India. So that there is a settlement, Union of India doesn't dispute. The Learned Attorney General also made it clear that the Union of India does not dispute the authority of the then Attorney General, an advocate on record for the Union of India, in the case of settlement. But he submitted that this should not preclude the Union of India from pointing out circumstances which, if accepted, would detract from the legal validity of the settlement. all the contentions are noticed, but I won't take up your lordship's time reading them. In fact, one important factor in the chronology of events as they evolved in those days. The settlement was arrived at when the challenge to the validity of the act is still pending. So the settlement became a point of argument in the act challenge, in the virus case. And one of the points was raised by Mr. Shanti Bhushan, saying Order 23 Rule 3B principle should have been followed before entering into the settlement. Your Lordship said that we did not set aside that settlement. And it was in that context, a full discussion is done. Please notice at page 632 printed, page 70, para 77, but that order of 15 February has been read, reread, and beaten to death. Please just see, ma'am. The order of 15 February refers to written memorandum filed by both learned counsel. Then starts the discussion from paragraph 106. One of the arguments was that your lordships allow the union to argue that point at para 108. But this point ends starting from para 115 and ending at para 122 at page 650. On a consideration of the matter, we hold that the doctrine of stifling prosecution is not attracted in the present case. About the unfairness hearing, which one? Yeah, sense of proportion. Now, two important things, please see. Page 120, page 652, para 127. Gives your lordship a sense of what was the lay of the land at that time. We made the inquiry. So that finally that 500,000 claims came to be accepted. Even in as early as October 90, there were already 600,000 claims. Because they are in purity. If in review this was not considered good enough ground to knock the settlement sideways, this can be a curative, can't be a second bite of the cherry. Then it goes on to say it was stated that a considerably large number of claimants who were asked to appear did not turn up. Medical folders, total number of deaths had written so and so. Medical evaluation has shown so and so. Then a whole figure is And what is important is the discussion from page 655 from para 130. I don't propose for that. I want to finish quickly. I don't propose to read all these paras. There is a full discussion about whether you can have multiple actions sequentially,
Split trials or quantification.
split trials. And this whole the whole discussion goes on. And at para 134, this point is put to rest. But the petitioners say that in the process of evolving what is fair, reasonable, adequate, some of the elements of essential relevant to fairness and adequacy, such as provision of future medical surveillance and the likely future but unforeseen manifestation of toxic injury, having regard to the nature of the hazard, have not been kept in mind, and therefore please mark these words. The approval accorded to the settlement is on an incomplete criteria. But the UCC would say that the Union of India was aware of the possibility of such future manifestations of the effect and must be deemed to have kept those in mind at the time of settlement. But the point to emphasize is those who are not parties to the process of settlement are assailing the settlement on these grounds. In personal injury actions, the possibility of further aggravation of the condition and consequent aggravation are taken into account in the assessment of damages. The estimate of damages is a very delicate exercise requiring evaluation of many criteria, some of which may border on imponderable. And then, Malad, the whole discussion goes on this. And it ends by saying, even if the award is a once for all determination, these aspects will be taken into account. And then, after discussing the fairness hearing principle, page 97, in our opinion, I'm showing this because one of the American jurisprudence has been.
What is the paragraph number?
I'm so sorry, para 140. The American principles, your lordships have said, will not apply. Para 140. In our opinion, the right of victims relating to Section 4 of the Act to express their views on proposed settlement does not contribute to a position analogous to that in the United States, in which fairness hearings are imperative, either on their global settlement. Section 4 of the Act, to which right is traceable, merely enjoins the Government of India to have due regard to the views expressed. The power of union under the Act to enter into a compromise is not necessarily confined to a situation where the suit came to be instituted on behalf of the victims. Statute enables Union of India to enter into a compromise even without a suit. The right of being heard and read into form and subject to its constitutionality has been upheld in Sahu, subjects the Union to a corresponding obligation. But the obligation doesn't envisage a procedure like the fairness hearing as the condition precedent to a compromise that the Union of India may reach in a situation in which it may do not necessarily to a suit. Accordingly, contention G is answered. The whole settlement is not vitiated for the reason alone for want of a fairness hearing. Likewise, the settlement is not vitiated by reason of the absence of a reopener clause built into it. Now, your lordships have not been shown any statute which was overlooked by coming to this conclusion, or some binding judgment of this court to the contrary, which was missed. In saying in a curative, this is a big egregious error. Please correct.
No, whether contention of the Union of India that award this consent order should be set aside, settlement should be set aside. Is it recorded anywhere at the time of hearing in this judgment?
Yes, Madam. Union of India challenged this.
No, whether Union of India argued before the review court that the settlement should be set aside.
Yes, they did. In fact, they went to the extent of saying this is for stifling prosecution opposed to public policy. Set aside the whole settlement. In fact, para 142, It immediately answers what Madam Justice Doka is putting to me now. Para 143, please see.
Yes.
The stand of the Union of India and other petitioners is that even upon setting aside of the settlement, fund should not be allowed to be repaid.
Right.
So they clearly challenge. Now the question was, what happens to the money? Your lordships in 142.
Well,
05, you read out.
Para 12.
Yes.
In here, Chief Justice Mishra's
Yes.
judgment.
And Union of India, paragraph 9, sorry. Paragraph
9.
Nine.
Correct. Supported the stand.
Correct? Who have asked for a review. And in fact, one of the subject there to Mr. Vikraj, he wanted me to read a paragraph. There, the union was criticized. The union was criticized for running the stifling of prosecution point. Where your lordship said, behold, that the doctrine of stifling prosecution is not attracted in reaching the conclusion. You don't put out a consideration that Union of India would, under threat of prosecution, coerce UCC to pay 470 and apart. In the context of the Union of India, the plea lacks as much reality as any sense of proportion. In fact, the argument was interesting. It is bad because under threat of prosecution, UCC agreed to pay. Lordship said this argument is not only bad, it lacks sense of proportion because. But PC page 98, para H.
Para H.
Yes. This also, my lord, answers your lordship's point. If your lordship sees para 3, keep the money back till such time as the decree is passed in the suit. What they were saying is, restitution, yes, we will keep it in trust to appropriate against any decree which may be made.
Suit should go back then.
Suit had to be tried. Page 661, para 146.
146.
Then, my lord, one of the arguments was, may I read from 145? The learned Attorney General also sought to point out that UCC had subsequent to the settlement effected certain corporate and administrative changes, and without a full disclosure by the UCC of these changes and their effect on the interests of the claimants, the fund should not be permitted to be taken out of the court jurisdiction. However, Government of India also should not be free to appropriate or use the funds. We are not impressed by any of these contentions. It is not shown that the UCC brought in monies with any undue haste with a view to confronting Union of India with the fait accompli. The records indicate a different complexion of the matter. The payment appears to have been expedited at the instance of the Union of India itself. Strictly speaking, no restitution in the sense of any funds obtained and appropriated by the Union required to be paid by the back arises. The funds brought in by UCC are deposited in the RBI.
Ultimately, court says that restitution will follow, but that safeguard should be maintained.
Correct. Well, that will be, but they said in any case,
Right.
it will be done.
Court says.
Because, my lord, one very important thing your lordship say in 148, and this is the strength of our system. However serious the incident may have been, the rule of law, my lord, has to stand.
Yeah.
And in the middle of para 148, your lordship says it is the duty of the court to ensure no litigant goes back with the feeling that he was prejudiced by an act which he did on the faith of the court. That's a very important consideration. Then para 153, your lordship says, we are satisfied.
Just one minute, just one second.
Now it's more. And what has become more is 50,000 has become 500,000 of minor injury. And that's the long and short of the purity.
Yeah.
I submit that fact. There's no top-up issue. That's, I don't think I can assist your lordship anymore on this. There are a lot of series of, I'm only staying it in 2 minutes. Series of affidavits filed. Series of affidavits starting with 1994, 1995, and ending as late as 2011, where the Union of India has opposed every single attempt to suggest that the settlement is inadequate. Affidavit upon affidavit upon affidavit. Argument before your lordship says the settlement has become adequate because the rupee depreciated. Go back to 89 and compare. But that can't be a ground for top-up in the long and short of my submission.
So Salve, which are the pages of the affidavits where prior to curative?
Yes.
They keep saying that.
That's very important. May I very quickly show 4 or 5 pages and then I'm done.
Just give me the page numbers. That's all.
First is volume 9, 12 December 95.
That is your volume 9.
Yes, ma'am.
December
95. There's a,
What page is this?
yes, it starts at page 2149.
Okay.
Please just,
That's fine. Next.
yes, please just mark para 5 and 6.
Yeah.
Then, my lord, 2003, there is a 32 petition file in which your lordship direct disbursal, where this 1,300 crore figure came in, the 1,500 figure came in. That's only, my lord, for the record. Your lordship's order is at page 2067 of volume 8.
Mr. Salve,
Yes.
can you do me this favor ask the instructing council on
a piece of paper.
On a piece of paper, just give the.
There is a written submission which I am filing and which I am inviting your lordship not to waste your time reading, except maybe
Does it
to assist you on these pages.
Does it have the paragraph number?
Yeah, it does. Beyond that, my lord, please don't waste your time reading it. I mean, it says nothing more. It says in 20 pages what I have said. 10 minutes to your lordship. And I don't think the matter requires.
I just need those instead of noting down, so there is no easier to locate those. That's all.
Are you doing it? TDCC, we don't want to do. Copies, please hand over. Your lordship had asked us to file written notes. So this is that written note. What your lordship is looking for. Yes, it's in Roman 5, page 7 onwards. Extracts are given in page number. Put all of it. Yeah.
Thank you.
Not unless there's anything else I can assist.
Thank you.
And since your lordships have not discharged the alternative board, I take leave.
Thank you.
And we ask you to approach and report once.
Anything you want to say, Penny?
Not just to. Sorry.
Yes, anything else, Attorney? I think both of you already debated it. What can be an rejoinder in this?
I think we will even do it even earlier if possible.
No, you want to say something? I thought there's nothing
I-
to say one
I
way or
only-
the other. We have
a
understood
couple
the
of
point.
things
The
just to say.
point is in a limited compass. Yes.
It won't be any manner of repetition. Right?
Okay.
To tie up certain threads.
May I be excused?
Either threads are open or closed. If they are still open, how will you tie them?
No. We have traveled quite a distance in understanding a lot of things had to be unraveled to comprehend. There are so many things that have happened over a period of time, and I looked at again. There are three claims in the curative petition. One on the compensation amount to be upgraded. The other in relation to the environment mitigation, and the third in relation to the expenditures and rehabilitation and all that. So when the curative petition was filed, the Madhya Pradesh High Court was still in season of a writ petition filed challenging the issue of environmental mitigation. And the respondent then entered appearance, some objections were taken, and I'm told they had placed before the High Court certain documents in confidence, which I had no idea at all. And after the review, the curative petition was filed, the Union of India had filed a transfer petition, which is also tagged along with the curative petition and is heard along with that. But since the High Court is in season of the matter, the question whether they would be subject to a liability on that question or not is still a matter at large. And I don't think in these proceedings I could probably ask your lordships to go into that question because a number of other issues that arise, I don't think
That may not be appropriate.
fairly stated and on a high level of integrity of the procedure. We are confined to the question of the liabilities as far as the quantum of compensation for the victims are concerned.
This transfer
So, muddle up,
the TP is also listed before us.
Yes,
It is listed.
there's a transfer petition which is
501.1.
That is filed by you.
Union of India had filed a transfer petition, and the transfer even was not even ordered. Unfortunately, it was lying pending with the court.
So simplest thing is to pass a
So,
dismissal
what
order
it
and
says is the High Court is in season of the matter, and the
Yeah.
High Court will
Transfer
continue to
petition.
hear the proceedings.
dismiss the constitution. That's all. Don't say anything more.
And say the High Court will give the petition number.
No, once we dismiss the transfer petition, that means we are not transferring it before us. That's all.
And I know, but anything Lord's State regards the continued liability of the UCC and this may or may not come in the way of the High Court.
You've not.
On the question of any liability on any other account, because I know there are some passages in the judgment which
We are not touching that.
obliquely looks at it, but I don't think
We are not
directly has a
touching that.
bearing on. And the other issue also I think should be connected. I don't think I can also go in the question of the rehabilitation exercise compensation paid on that.
Cannot.
Because that's a matter on there could be more than one point of view, some factual, today we not even spend that money. How much more we'll spend all that? I don't think. So though they are part of the claims for some very policy reasons, they've been brought as part of the curative petition, but maybe for good reasons, I would confine myself a little bit. Now, I look at the turn of events over a
So
period of
claim
time.
3 you are not pressing.
Yeah, they can be pursued in accordance with law in appropriate procedure.
Appropriate process. Claim 3 goes there.
That's right. The review judgment broadly looked at 2 or 3 troubling issues. While it is true that Union of India did not itself file a review petition but supported the review proceedings, and in the penalty paragraph of the affidavit, it says that the settlement may be deserved to be reopened. So the extent of reopening, the nature of the degree of opening, whether it is to completely undo the settlement or to have a review limited to the extent of looking at the quantum of compensation, where probably that was the main focus, it seems to be, as I read the affidavit in total.
See, in the background of the order in the review petition, you are wiser in the curative petition to the extent you would like to claim.
Maybe wiser, little more wiser.
So
No, I look at the, I
you-
look at,
Therefore, you were fair to say that, look, in view of the proceedings gone by, it's not even advisable to pray for reopening the settlement. What you are, therefore, any time I said you want the settlement to be talked up.
exactly.
Yes, it has happened. There are certain other
Exactly,
facts,
exactly.
intervening circumstances
Exactly.
and facts which would require the court, according to you, to exercise whatever inherent power, whatever power you feel, look at a larger perspectives of the situation.
Great.
And in that process, you feel something more should be added to
That's-
it, given the figures and facts and figures which you
That's. Well, I look at the affidavit only from that perspective, and I think that must have been the whole idea behind it. I don't think Union of India, having gone into the settlement and supported it, said right for the immediacy and all that, but I said undo the settlement fundamentally. I don't think that was probably the intention. So the review judgment had looked at some of the basic concerns urgent for the claimants and the writ petitioner. One is that having been kept away in the entire process of adjudication and Government of India had taken over the right to represent us. So there are several casualties, the fairness hearing and the participation in the settlement procedure and so on and so forth. And the quantum of settlement, the figures, how do you arrive at these figures? There could be no finality at this point of time. All those very important concerns were raised before the court. And they're all summed up in paragraph 55 in several contentions. Paragraph 55 of the review judgment. And there is observations made in the context of one, probably has been read in the context of some other contention. Therefore, I thought important for a purpose that the contention raised in respect of each one of those must be kept within the scope of those contentions. And sometimes you read one in the context of one, that could be a small.
A to H. A to H.
That's right. That's right. Now, therefore, the paragraph 55, contention F is about, this is paragraph 55 of the review judgment. So I read from volume 1 of the respondent's compilation. The other contention relating to criminal prosecution, court settlement, I'm not looking into all of them. Contention F is the memorandum of settlement. The orders of the court thereon properly construed make inference inescapable to the part of the consideration whether stifling of the criminal prosecution is opposed to public policy. This vitiates the agreement on the settlement is based on unlawfulness. That one contention relating to criminal prosecution. Then turn over to contention H.
That is regarding restitution.
Contention H, yes, restitution. Even if the settlement is reviewed and set aside, there is no compulsion or obligation to refund and restore to the UCC the funds brought by it as such restitution is discretionary. Excise and discretion, the interest of the victims is kept in mind and restitution denied. But all, even if restitution is to be allowed, the UCC would not be required to act upon and effectuate its undertaking dated so and so on the basis of it, order dated so and so, vacating the injunction against was made. Then contention J. That the settlement required to be set aside in the original suit directed to be proceeded with on the merits. If so, and what other reliefs required to be granted, what are the directions required to be issued. So when you read contention J, let me read the first with contention H at page paragraph 142. 188. At the same time, it's necessary to remind ourselves that in bestowing a second thought whether a settlement is just fair and adequate, we should not proceed on the premise so has been finally established, yet to be decided in the matter goes to trial. Because all those things went into the decision-making process of the court, looking at whether I should undo the settlement at all. So when the court has ultimately thought we're not going to undo the settlement, but we'll still, that's why when it gave a final thought on the question in paragraph 205 about what happened to the future symptomatic now, asymptomatic now, symptomatic later. So that's where those people may come for a claim later, we should take care of them. It ends at that. It ends at that. I would probably look at us, Your Lordships, to read this review judgment and the first order of May 4, 1989 together. Please read them together. Even if there was no reopener clause in the settlement, but the court in the 4th May 1989 order, the final paragraph, for all practical purposes, is the reopener clause. It is a reopener clause that the court has introduced into the settlement because the wide range of complexities which a matter of this nature was brought to the fore of the court. If I am not too off the mark in requesting the court to read it as the reopener clause, kindly come back to that. It's been read again and again, but so paragraph 38 of the settlement justification. So having said this, I thought, the way one can read it fairly, the review judgment thought there is already a certain guarantee and that can probably take care of. That's why although the arguments about settlement did not have all these concerns, those fairness opportunities are not there. So that, I think, in all fairness, to whatever extent justice may be done, paragraph 38 may be read as the reopener clause, and we read these judgments, we read as one continuum of a judicial process. They may have happened at different points of time, but one.
No, but in fact, settlement was specifically challenged on the ground that there was no reopener clause, and that
in the settlement.
Correct. And that contention has been specifically rejected.
Right. That's right. In the settlement, there was no reopener. But while the court endorsing the settlement had this in mind. So what was lost in the settlement was compensated and adequately taken care of with this paragraph. In all humility, and I don't think I'm doing injustice to reading judgments this way. If the judgment meant something, that's why I said this probably would not go in vain. So if that would not be too wrong to read it as part of judgment to be read as a continuum, and this as a reopener clause, to whatever extent Union of India got to Your Lordship's notice, the unfolding events over a period of time, and I also read out that the ex gratia payment will be excluded under the scheme of the Act and all that. That's why I thought it is in a matter like this, while the undoing of a settlement has been put to rest by a curative petition and having regard to the intent of the Union of India in the affidavit filed in the review proceeding, the curative petition must be taken to a certain level where if the ends of justice of those waiting for justice for long can somehow be secured. And that's where probably the curative petition will be looked at. And I've seen all those proceedings in US. I placed on record about the complete lot of settlements. And those, I just give an index of those documents, where the US procedures on fairness hearings, and there are doubts raised whether for future claims, how do you look at them? So a bankruptcy process is also sought to be introduced in all those settlement issues. So it has flown in different directions. But ultimately, it's kept open. All these long proceedings in US, as business particularly, it kept open the possibility for people to secure probably the ends of justice at some point of time. So you put it on a higher level of principles of natural justice. And like all that you say is, I'm sure I must have had my day in the court Your Lordships, that's how it's put. So ultimate questions come to the mind of a claimant is, did I have my day in the court at all? I have so many years of waiting. So yesterday I did not point to your Lordships about those fraud and mistake. Just a couple of paragraphs of
The paragraphs of what written?
No, I'm not looking at those documents about suppression of facts as a fraud from the point of view.
What are you proposing to read?
Your Lordship, please.
What are you proposing to read? I want.
No, I'm just giving. We have placed on compilation of articles and extracts from books.
Yes.
There's a yesterday when you lost rising, the concept of a fraud mistake is so wide. It's so wide. That's all I wanted to point out. If it is so wide,
Not the time period, then say arguments concluded or the result.
Point will not I want.
No second, third, fourth.
It's only what I'm trying to say is only will not. It's a very
Please understand. Some discipline of the court
I
proceeding
will
must
not
be
answer
maintained.
that.
We have heard both of you
No, I will
against
not-
reasonable time. Now in a rejoinder, we will not.
Not rejoinder, but I'm not. I'm just trying to inform them. No, not rejoinder. What I'm trying to say is, there is a figure which has been given. Now, in addition to that, once the medical documents are made available, it will increase. Plus, not the future. So therefore, that will be an anomaly of the problem. That's all I wanted.
Thank you.
I'm grateful to that.
Deeply obliged.
Thank you.